Item number 1.
May it pleases your lordship. My lord, this is an writ appeal against the judgment and order dated 14/8/2024, passed in WPC number 56 of 2022, my lord. The facts of the case is that, my lord, in pursuant to the NIT dated 17/6/2021, the respondent was appointed as a road transport contractor, and he was issued an letter of acceptance dated 23/8/2021. And in pursuant to that letter of acceptance, he was to submit security deposit, my lord. But instead of submitting the security deposit, he made a request on 10/9/2021 that he cannot manage the security deposit, and hence his tender may be cancelled. So, my lord, the FCI has terminated the tender, my lord. The termination letter is at page 107, my lord. My lord, may kindly come to page 107.
Yes. Yes.
Yes, my lord. The operative part is at next page 108, my lord. Paragraph 5. Thus, it is clearly established that Messrs. RG Enterprises has failed to submit the required security deposit amounting to rupees 7,60,000. So and so, so and so. So, my lord, the next paragraph 6. Therefore, in exercise of the power conferred under clause 11E, which speaks in the event of the tenderer failure after the communication of acceptance of the tender by the corporation to furnish the requisite security deposit under clause 7(1)(a) by the due date, or requisite security deposit in the form of bank guarantee under clause 7(1)(b) and 7(1)(c), including the extension period, his contract shall summarily terminated besides forfeiture of earnest money, and the corporation shall proceed for appointment of another contractor. Any losses or damages arising out of and incurred by the corporation by which the conduct of the contractor will be recovered from the contractor without prejudice to any other rights and remedies of the corporation under the contract and law. The contractor will also be debarred from participating in any future tenders of the corporation for a period of 3 years. After the completion of the prescribed period of 3 years, the party may be allowed to participate in the future tenders of the FCI, provided all the recoveries dues have been affected by the corporation and there is no dispute pending with the contractor party. The Road Transport Contractor Act XRH FSD Bhalakpung to FSD Bomdila accepted by this office-wide acceptance letter cited at reference number 2 is hereby summarily terminated with immediate effect, and the corporation shall proceed for appointment of another contract at the risk and cost of the terminated contractor, that is Messrs. RG Enterprises. Any losses or damages arising out of the same and incurred by the corporation due to the conduct of your firm would be recovered from Messrs. RG Enterprises without prejudice to any other rights and remedies available to the corporation under the contract and the law of the land. The tenderer is also debarred from participating in future tender or the corporation for a period of 3 years under the MTF clause 11E. So, my lord, this letter was this termination letter was challenged before the learned single judge, and the learned single judge, my lord, by judgment, impugned judgment and order dated, partly allowed the writ petition. However, at paragraph 17, my lord, at page 160, my lord, the operative part. Paragraph 17, may I read it, my lord? Accordingly,
Yes.
the present writ petition is allowed by holding that the petitioner cannot be put to risk and cost as prescribed in the NIT dated 25/1/2022. However, the FCI is at liberty to approach the appropriate forum for recovery of damages, if any, for the conduct of the petitioner, if so advised and if permissible under the contract. My lord, that risk and cost was allowed, my lord, only because of that the contractor has not furnished the hard copy of the MTF. My lord, in this regard, I want to rely on clause 8C, my lord, at page 78, my lord. Page 78, my lord, this is the agreement, my lord. Clause 8, my lord, submission of tender. Then C is relevant, my lord. May I read it, my lord?
Yes.
Clause 8C. The envelope packet in online containing the technical bid shall include the following: all the annexes and appendices of the MTF duly signed, my lord. Duly signed on each page by the tenderer should be scanned and uploaded in the e-procurement portal. My lord, what happened that if we appoint a tenderer, then we ask them to submit the hard copy, but they have already uploaded the signed agreement, my lord. Signed agreement in the e-portal, my lord. Your lordship will find the RG Enterprises signature down below at page 78, my lord. Messrs. RG Enterprises, this is the signed tender. We only wanted this hard copy. So learned single judge only held that because the hard copy was not submitted, so the contract was not concluded. So we cannot invoke the risk and cost factor, my lord. So, my lord, at this stage, notice may kindly be issued.
Careful.
Yes, madam. It will be very stable, madam. Because, madam, one clause in madam 12C in judgment matter case 157 onwards, madam. One of the condition matter for issuing the letter of acceptance in matter presented by madam. First, madam, on accepted matter, on being a successful bidder matter, the requirement under clause 8 is matter, E is that matter. I should matter submit the hard copy matter, all the signed copies of the hard copies before the FCI matter, in order to get the letter of acceptance by the FCI matter. Before issuing the letter of acceptance, before receiving the matter and to hard copy of the document matter, they have issued the letter of acceptance matter. So tender agreement is not, contract is not complete matter. This was not observed by the single judgment. May I raise the observation of the matter?
Yes.
Page 10 onward matter.
Yes.
Page 157 matter. There are 9 onward matter. May I read matter?
Yes.
In the aforesaid background now, let this court consider the terms and conditions of the tender document. The first relevant provision is clause 6 to prescribe deposit of earnest money at the rate of 2% of the value of contract to be submitted electronically along with the big document. However, there was an exemption that MSME need not deposit such earnest money. I have MSME matter, small, micro, small, medium enterprise matter, and I am exempted of the submitting the earnest money. Clause 8 deals with the submission of the tender. Subclause A, B, and C of the clause A prescribe and mandate that documents and request to be uploaded in the e-mail. Since the subclause E of the clause 8 is the bone of contention, let this court for the sake of which is approved. This is the required matter clause matter. E. Tender should be uploaded, submitted for e-procurement. Manual bid, hard copies of the tender document will not be accepted. However, the successful tenderer matter will have to submit the original hard copy of MTF duly signed on each page of the MTF along with the annexure duly attested on or before the date and time stipulated by the FCS. Failing which the EMD so furnished by the bidder is liable to be forfeited, and further the award of contract or the letter of acceptance will be issued to successful tenderer only after he fulfills his requirement. Only after fulfilling by means of submitting the signed bid documents then only letter of acceptance will be issued to me Next page From the aforesaid, it is clear that subclause A prescribed that the tender is to be uploaded for e-procurement at the designated web portal. It further mentions that the manual bid hard copy of the tender document will not be accepted. The said clause further prescribed that successful tenderer will have to submit the original hard copy of the tender document duly signed on each page along with the annexure appended to be attested on or before the date and time to be stipulated by the expert. It is also mandated that on failure the tenderer to submit such document, EMB furnished by the bidder shall be forfeited, and FCI can award a contract for a letter of acceptance only after fulfilling the requirements chosen prescribed under the law. It cannot be minor. Letter of acceptance cannot be preceded by minor the submission of the document. In case in hand, it is admitted position that FCI after completion of tender process did not notify any of clause 80. It is also admitted position that the petitioner also did not receive or submit as hard copy in terms of 8E, and as that still the letter of acceptance was issued, which the petitioner refused to accept on the ground that petitioner had decided not to execute the work and therefore did not submit the hard copy to be signed. Accordingly, in the opinion of this court, under clause 8E, on the admitted background that no procedure was finalized or completed as regards the submission of the signed hard copy of the standard document, it cannot be said that the contract was executed. Yes, because I have not submitted the signed document, hard copies, there cannot be any contract between the bidder and the FCI. Even if it is assumed that the acceptance of the letter of acceptance is initiated on contract and there is no necessity of signing a separate contract, but under the terms of the tender, submission of hard copy of the tender document is conditions precedent for issuance of the letter of acceptance. Therefore, it cannot be said that there is a signing of contract, more particularly for non-address or submission of signed hard copy of the tender document. Or 80 instance and in advance escape into the second without putting clause 80. Therefore, there was no contract on the date when the letter of acceptance was issued to the petitioner. In as much as recorded herein above, clause E of the clause 8, the FCI to issue a letter of acceptance without fulfillment of the provision that a hard copy signed will be signed with furnished to FCI. There being the position in the considered opinion of this court, the FCI could not have proposed to execute the work in the recent court of the petitioner had not became a contractor by that time and there is nothing wrong in the finding of the non-citizen. So it is still no interference by the court matter.
Will issue notice?
My lord, I have a reply, my lord. My lord, may kindly see page 106, my lord. The respondent letter to the FCI, my lord. Now he is taking a plea that just because the hard copy have not been submitted, it cannot be termed as the page 106, my lord.
For not accepting the matter, letter of acceptance, declining the provision. My letter to FCI.
My lord, page 106. This email was issued by the RG Enterprises to the FCI, my lord. Sir, with reference to the above subject, I have the honor to state that due to unavoidable circumstances, I could not make security deposit and bank guarantee amount to the FCI Itanagar. Therefore, I request to cancel the letter of acceptance in regular road transport contract Acts Balakpung to FSD Bombila. My lord, he himself is stating that kindly cancel the contract, my lord. He has accepted the letter of acceptance. Now, just because this because of the termination, these clauses will follow, my lord. Just to avoid that risk and cost clauses, my lord, he has now taken this plea that hard copy has not been submitted. Whereas, my lord, if your lordship will see from page 72, they have submitted the agreement, my lord, with signature, my lord, and uploaded in the e-procurement site, my lord, from page 72 onwards, my lord.
Hard copy.
Yes, it is not hard copy. I am also saying it is not hard copy. This agreement, my lord, was uploaded, my lord, after signing, my lord. So what I am submitting at this stage, my lord, it needs a detailed hearing, my lord. Notice may be issued, my lord. A date may be fixed for final disposal, my lord. From
Mr.
page BK Singh.
Land Council for the appellant. Okay. This is an appeal filed against the judgment and order dated 14/8/2024, passed by the Lana Single Judge in WPC number 56/2022. Stockholm. Issue notice. Since Mr. R. Soitya, standing counsel for the, okay, respondent number 1 and 2.
Sole respondent.
Sole respondent. Okay, before the single judge, there was a 2 respondent appeared on behalf
That FCI was. Now that
appeared
respondent has
accepted
become appellant.
accepted on notice on behalf of the sole respondent. No formal notice need be issued. Then we'll list this matter on
After 4 weeks, my lord.
after 4 weeks. Okay.
Deeply obliged, ma'am.
Item number 2.
Mhm.
Your Lordship, learned counsel for respondent M. Rangan could not appear today just for personal reason. Therefore, this matter will be kindly fixed after 2 weeks. Consent of the other party is not to be told.
Okay. We are for the respondent. Okay. Mr. Learned counsel for the respondent premised that the conducting counsel, Ms. Nikita Dangan, learned counsel for the respondent, could not appear court today due to some personal difficulties. He has also obtained consent from the learned counsel for the appellant and accordingly prays for adjournment of the matter for 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Item number 3 and 4.
Hmm. Not yet.
Respondent number 3, state deposition.
Okay.
Other respondents.
What about the other respondents? You have
But the main affidavit will.
main respondent is 3. Okay. Ms. Jaya Doji, learned counsel appearing on behalf of the respondent number 3, prays for further 3 weeks. Time to file affidavit on a counter affidavit. To which the learned counsel for the petitioner has no objection. Mr. N. Ratan, learned additional AG, appear on behalf of respondent number AG for the is present on behalf of the respondent number 1, 2, 4, 5, and 6, and Mr. Pang for respondent number 9 are also present. Okay. List this matter is prayed for, list this matter after 3 weeks. Okay.
Item number 5.
Okay. Seeking time. Who is appearing on behalf of the respondent? Hmm? Not appearing today. No, they were not yet filed.
What happened to the SLP? Is it not yet disposed?
This was to be listed third week of January. Okay. Ms. D. Tamuklan, counsel for the petitioner is present. None appears on behalf of the respondent. The nor file any counter affidavit. You have any idea this SLP was listed? Okay. In absence of the Lorraine counsel for the respondent, the matter is stand adjourned. List this matter after 2 weeks. Okay.
Item number 6.
We have taken step on 5/12/2025. And the notice is yet to be served to the respondents. Only the respondent 5 have appeared, the rest they are yet to appear. So we have taken step and then we will be filing affidavit the status of the service. As per the earlier directions that we have to file the status of service. So we are kept online. Now, as per the online to show that this it is still on the not being served.
So what do we do? You want to serve? Take fresh steps or what?
Wait for some more days, and then once it is completed, we'll file the status of the service.
So respondent number 5 enter appearance.
Yes.
Okay.
Saxena is appearing for respondent 5.
Hmm. Mr. Esmo, Lorraine counsel for the appellant, submitted except for the respondent number 5. Service upon the rest of the respondents are still awaited. And he was directed to submit a postal threat consignment report. However, he could not submit the same and prays for some more time. Prayer allowed. List this matter after 2 weeks. Okay.
Okay.
Item number 7.
It's for continuing video for 2 days.
Okay.
For that, 1 to 3.
You want to file objection?
Yes.
Yeah. Okay. Mr. Land counsel for the petition. Applicant is present. Mr. B. Pitcher, Land counsel appearing on behalf of respondent number 1, 2, 3. Press for some time to file objection. How much time? But praise for 3 weeks time to file objection. The prayer is allowed. List this matter after 3.
Item number 8.
This IA is for what? Okay, okay. Filed by you. You are for appellate. And is IA, AC is respondent. No, respondent in the writ appeal. Okay, you are for? El Parma is for? Who filed is IA? Okay, why you want? Time? Okay. Now the interim order is in your favor. Okay. They have filed this application for modification,
For review.
review. You have an objection. You want to file objection? Mr. Asira, Land Council, submits that Mr. El Parme, Land Standing Counsel for the Power Department, could not appear today due to some personal difficulties. Therefore, pray for some adjournment, prays for adjournment of the matter for 3 weeks.
Fixed it.
Okay. You want to file objection to this? Already filed. Okay. Mr. Your name, good name?
Ragbinder Rai.
Binder Rai. Appear in person. And some is that he has already filed objection. He is prayed for by the Land Council for the appellant. The matter stand adjourned. However, on the request of the Land Council, the appellant in person, let this matter be listed on. 9 to? Okay, on 12. Sorry, 11th. 11 February. Okay.
Item number 9.
Okay. Mr. Land Council, Sam Mr. The leading counsel is out of station. Therefore, pray for adjournment, to which Ms. Riba, Land Additional Government Advocate has no objection. Prayer allowed. List this matter after 3 weeks. Okay.
Item number 10.
Therefore, the matter will be then picked after 2 weeks.
Okay. You are Mr. Land Council, some Mr. The conducting council, Ms. N. Dangan, Land Council for the appellant, would not appear today due to some personal difficulties. Therefore, pray for adjournment of the matter for 2 weeks, to which Mr. M. Kato, you are Mr. El Sora, Land Council appearing on behalf of Mr. M. Kato, Land DSG, for the respondent has no objection. Prayer allowed. List this matter after 3 weeks, 2 weeks. Okay. Yes,
He has a instruction to.
item,
Has an instruction to do the. I name on there, I am on behalf of.
okay. Mr. S.K. Deore, Lana Council appearing on behalf of Mr. D.K. Deore, submits that he had an instruction to withdraw this writ petition. Oh, why? Okay. No objection. Okay, start. Okay, Ms. Pango, Lana Government Advocate. You are also
I for private respondent 5.
for the Lana Government Advocate appearing on behalf of the state respondent and Mr. Karwa. The lawyer, Lana Council for the respondent number
5.
and private respondent number 5 has no objection. In view of the above, the prayer for withdrawal is allowed. Accordingly, this writ petition stands dismissed as withdrawn. Okay? Yes.
On behalf of Professor S. Pandey, who is from Delhi, for item number 3 and 4, due to some personal difficulties. This matter may be accepted.
Okay, Mr. Bhattacharya, Lana Council appear, submits that the, Mr. I.S. Pandey, S. Pandey, Lana Council for the petitioner. Have you informed the other side? Submits that the Mr. S. Pandey, Lana Council for the petitioner, who is stationed at Delhi, could not appear today due to his personal difficulties. Therefore, pray for adjournment. Prays for adjournment, to which the Lana Council appearing on behalf of the respondent has no objection. Accordingly, the prayer is allowed. This matter after 3 weeks. Okay. Item? Yet to file? Okay. The counsel for the petitioner is present? Okay, Miss,
After 4 months, compensation.
after?
Compensation letter. Sí, los fondos no pagan de
Okay. You are Miss? Lana counsel for the petitioner is present. Miss Sangeeta. Lana counsel. Lana government advocate for the state respondent. Praise for how much time you said? 3 weeks. For the 3 weeks time.
4 weeks.
Okay. So if it is for the last chance, you want to fight last fight. Okay. Praise for further 4 weeks time to file affidavit in opposition. Okay. The prayer is allowed. List this matter. The prayer is allowed. Huh? However, just a minute. Huh? What you said? How much time you have taken? It's 25 case only, 25 case only. List this matter after. You have taken earlier also. You have taken time. Okay. Praise for further 4 weeks time. Huh?
Last one.
The land council for the petitions has shown some urgency and some that it should be a last chance. Okay. The respondent is given
Twenty-one and 22. This is for mediation. So that is not going to be better on the window. So that will be better maybe this is regular. That's right.
Who is okay, you are Mr. And your good name? And Atlantic Council appear on behalf of Mr. G. Kato, Atlantic Council for the appellant, Mr. Boluram. Atlantic Council for the respondent claimant. Respondent claimant is also present. The counsel for the party some is that there is no possibility of settlement of the matter through mediation. Therefore, praise that the matter may be listed. The matter may be taken up for disposal on merit. Okay. As prayed for, comma. List this matter. This is ready for hearing. Is the matter ready for hearing? Okay. Let's prayed for, comma. List this matter after 2 weeks for hearing. Okay. Which one? Item 31 only? 22 also, similar order. Okay.
Yeah, Your Worship.
Yes.
So I would like to motion item number 26. I, on behalf of the Board of Petitioner,
humbly pray for adjournment this matter, and this matter may fix on 5 February 2026.
Who is for the respondent?
My Lord, Arju Arnavam.
Okay. No inform.
Standing Council Arju. Respondent number 23.
Okay. You are Mr.
Marun Marde,
Parent Council appearing on behalf of Mr. T. Karum.
M. Marde,
Okay. Marde appearing on behalf of Mr. T.
T. Torum,
Parent Council for the petitioner. Praise for listing this matter on
5
5
February.
to which Mr. R. Nabam, Standing Council for RGU has no objection. Accordingly, the prayer is enough. List this matter on 5 February for hearing.
Well, highly obliged.
Now.
Yeah, please, Lordship. Lordship, item number 20, Lordship. Here I have received instructions. I may be allowed to file affidavit to bring on records the instruction that I have received.
When do you want to file?
1 week time may be given, or 2 weeks. 2 weeks time.
2 weeks. Petition.
I'm for the petitioner, my lord.
Okay. Mr. B. Kaushik, Land Council for the petitioner is present. Mr. Tapin, Land Senior Government Advocate for the state respondent, submits that he has received instruction and would be filing the affidavit within a week. Therefore, praise for a week time. Prayer is allowed. This matter after a week.
After 2 weeks.
After 2 weeks.
Yes.
Okay.
So the interim order passed earlier may be continued.
The interim order passed earlier shall continue till the next date of listing.
Yes, grateful.
May I please, Lordship?
Yes.
Lordship, I beg to mention unlisted item to be taken up today, Lordship.
What is this matter about?
Lordship, it is a Arunachal Pradesh Information Commission matter, Lordship. So, Lordship, there is some urgency.
File
Yes, Lordship. As a last matter.
tomorrow?
Lordship,
Get listed tomorrow.
Lordship, next date is on this February 4th.
That is why tomorrow. Get it listed tomorrow.
Yes.
List it tomorrow. Okay.
Deeply obliged.
My lord, I beg to mention item number 13.
It's in order. What it has been listed for?
Actually, we have to file affidavit towards respondent number 9. So we may seek some more time to file the affidavit.
You have to file affidavit.
Yes,
You're for the respondent 9.
a petitioner.
A petitioner.
Yes,
Affidavit in reply
yes, your lord.
to the affidavit filed by respondent
Respondent
number
number 9.
Yes, Your Lordship.
You are for respondent number
9, 2, 3, and 9, Your Lordship.
or 2, 3, and 9. Okay. Miss Item 13.
Yes, Your Lordship.
Okay. What was your name?
S. Somu.
Your name is not there?
Maybe it was filed before my coming here.
Okay. S.
S. Somu.
Some learned counsel for the petitioner. Submits that she has received an affidavit in opposition filed by the respondent number 9 and prays for some time to file affidavit in reply to the affidavit in opposition, so filed by the respondent number 9. The prayer not been objected to by is allowed. Okay. List this matter after
3 weeks.
age grade for comma. List this matter after 3 weeks. Okay.
3 weeks. Much.
Item number 1.
My please, Lordship. Malab, in this writ petition, we are challenging the manner in which the arbitrarily the permit granted for land development has been cancelled by the respondent authorities. Malab, before coming to the main issues, Lordship may kindly see page 48. This is the how
Page 4?
uh,
48. Page?
yes, page 48.
Okay.
Simply, madam, this is to show that how I got the property. This is a land this is gift deed. It should.
Allotment was in his name, some other name.
Yes. This
Whether the allotment has been changed in your name.
No.
Okay. It is still in the name of
Yes.
the one who gifted you.
Yes, but the issues is that by this gift, the land has been gifted. The allotted plot of land has been gifted to me, 500 square meter plot of land.
Okay.
Land. There are some official problems and all that because of that. It was not transferred, but the authorities knows about it. What happened thereafter? The respondent number 4. He started encroaching upon the plot of land, and the petition here have lodged a complaint before the respondent authorities.
He is your neighbor.
No, he researched beyond that plot of land, not even neighbor. So summons were issued, and thereafter the hearing was done by the state officer in this matter. And the state officer says that the complaint that has been lodged by me is correct. Now, your Lordship will just come, I'll just, page 25.
Yes.
Yes. Madam, just to shorten the matter, I'm reading from third paragraph. Whereas first hearing done on 6/9/2022, whereby complainant Srimati Meenu Dodam, that is the petitioner. Meenu Dodam, I witnessed Dr. Chape Pao, Srimati Dema Sonam Pao, Srimati Ila Jyoti Mize. She's the donor, Ila Jyoti Museum. And Srimati Nung Mize present, but respondent Tai Tale was absent. Likewise, order dated 6/9/2022. Second summon issued to the respondent Tai Tale to appear in person or through a pleader before the undersigned on 13/9/2028, 1100 hours for hearing of the case with all relevant documents of the things to testify the material facts related with the present case. Whereas hearing conducted today on 13 September 2022 at 1100 hours, both the parties which complainant Meenu Dodam and witnesses Dr. Chape Pao, Dema Sonam Pao, Ila Jyoti Mize, and Nung Mize, and the respondent Tai Tele along with his witness patching time present during hearing. Now, mark this, patching time. He is respondent number 5. He was witness of the respondent number 4 in this month. Heard both the parties in detail. Respondent. Yes.
He is
respondent number 5.
Who encroached? Who used to encroach your land?
No, Tai Tale, the respondent number 4 was encroaching.
Title and
Yes.
picture.
And he was witness of that respondent number 4, passing time. Because now his name is important because later on he was the person who filed the title suit now.
Pachintayam.
Yes. Heard both the parties in detail, respondent and his witness. We are given opportunity to present their case along with evidence supporting documents. Also, complainant and her witnesses provided opportunity to plead with evidence supporting documents. After careful consideration and submission of both parties, following facts are noted. Ila Jyoti Mije, permanent resident such and such, was in possession of land measuring such and such. Man, that's understood, man. Now, I'll not read entire thing, man. Now, you're kindly page 27, the conclusion.
Yes.
In view of the above submission, both the parties understand counter questions the complainant that whether they are ready to solve the matter outside the office procedure if an opportunity of time is provided. In reply, Dr. Chape Pao as party agreed. Also, same counter question was put forth to the respondent, however, Tai Tale disagreed. His contention was, first, he is ready to talk of settlement with Ila Jyoti Mije, earlier owner, and disagreed to talk for settlement with the complainant Minu, the present owner of the land. Taking into consideration of facts, materials in the instant case, this inquiry is dismissed with the following observations. Facts supporting documents evidence are in favor of the claim made by the complainant. Therefore, the Deputy Commissioner Itanagar pass an appropriate order in the instant case as deemed fit. That the categorical observation that claim of the complainant, the petitioner.
Complaint was lodged by
The petitioner.
It was dismissed.
No. It was not dismissed.
Dismissed.
It was disposed actually, not dismissed, with observation.
So this dismiss is to be read as dismissed.
Disposed actually, because he forwarded this order to the Deputy Commissioner thereafter.
Okay.
Therefore, Deputy Commissioner may pass appropriate order in the inside case deemed fit. The respondent is at liberty to, respondent also was given liberty to approach Deputy Commissioner to adduce further evidence if any in his defense. Now after
this is when this order was passed?
This in 2013, 9/2022.
That's way back in 22.
Yes. Now, Lordship, page 28. On the basis of the report submitted by the state officer, this final order was passed by the Deputy Commissioner.
Okay.
Page 28. Whereas a complaint has been submitted by Sri Minu Dodam, this is a petitioner, against Tai Tale, informing that she had received a plot of land measuring 500 square meters, Gopur Tinali Itanagar Wild Land Allotment number such and such, dated 7 September 2005, from Sri Midhila Jyoti Mije, through gift deed, but Sri Tai Tale has already executed illegal earth cutting through her plot of land and constructed an approach road to his plot without any prior notice, and hence the complainant has.
So declare that Tai Tale is trespassing.
Yes.
The land of the
Yes. Now the last paragraph. Therefore, in the light above observed, Sri Tai Tale is trespassing the land of the complainant, which is illegal in the eyes of law, and hence he is directed to refrain from using the site approach road through the plot of Srimati Minu Dodam with immediate effect. Agreed by this order, Manoj, the respondent for approach this honorable court. And we exchanged our pleadings, and the matter was for final hearing. And during the final hearing, Lordship, on page 29.
Withdrawn with liberty.
Yes. No, why? They knew that the case would be dismissed. And now respondent number 4 seeks permission from this honorable court. May I read, my lord? Page 30.
30.
Yes.
No, see, withdrawal accepted with liberty. As
yes. Now how that happened, page 30 mechanism. So from second paragraph. After arguing the matter at some length, Mr. Such and such learned counsel of a petition submits that he may be allowed to withdraw this writ petition with liberty to approach the civil court.
Okay.
In view of the fact that the issue involved is purely a disputed question of fact relating to land.
Okay.
Having considered submission of learned counsel of parties, consider that grievance raised is a petition purely a disputed question of fact regarding claim of plot of land and the approach over the land, and considering that the petitioner claims that the land is a private land, whereas now the petitioner says it's a private land, but it's it's obvious it's a government land, allotted land. Can claim land, private land, whereas stands response is that land is government land, prayer for withdrawals, etc. with the liberty is
Now, what happened thereafter?
Now, thereafter,
Civil suit filed.
the liberty was taken by respondent number 4. Then now, respondent number 5 files a title suit that for easement rights.
Okay, the 5 is neighbor.
He also neighbor of the respondent number 4.
Okay, but not the neighbor of the petitioner.
No. Now
The lane is beyond the
yes.
petitioner.
Yeah. Now in the title suit, interestingly, the easement right he claims, saying that he has constructed the approach road. That's why, Lordship, in the earlier I'm saying he was witness of the respondent number 4. He files a title suit for easement rights here, saying that he has constructed a road instead of respondent number 4.
Now he is no longer witness.
Now he has become he knew that the case of respondent number 4 would be weak. So now he approached the trial court for filing this title suit. Now they have, because I will not read the entire petition. Now here in the title suit, they also filed a miscellaneous application, also interlocutory application under order 39 for seeking injunction.
What happened there?
No injunction has been passed till date. That injunction petition was filed after 6 months of the title suit. So no injunction order has been passed yet.
Okay, then.
Now, because now this matter, if Lordship sees, this plot of land is a government land. In the title suit, if your Lordship says, government is not a party there. Only the petitioner and the person who gifted the land is the party in that suit. Government is not a party. Because the land development was pending, it was in dire need, and people were disturbing. So the petitioner sought permission to develop the land by excavating that area.
Come to main point.
Yes. Now, your Lordship may kindly come to page 99. This is the permit.
Granted.
Yes. Now, this may can you see?
What happened? Have you started?
Yes, madam. Now,
What have you started?
17th, madam. 17th January. Now we are
Permission was granted on.
yes, or 5th January 2002. Therefore, I'm allowed to read the first paragraph. Permission is here granted to Srimati Meenu Dodam, wife of Sri Ramsana, a present resident of Cherva Colony, Sepai, is coming this Arunachal Pradesh for land development and transportation of debris, mud, dumping at nearby Hat Resort, Chandranagar, Itanagar, against the land allotment number such and such, measuring 500 square meter Gopur, Itanagar, with effect from 17/1/2026 to 17/2/2026.
Okay.
And terms and conditions were given. Debris, first is that the second, that first is guidelines under 4.9 of Arunachal Pradesh Building Bylaws 2000 shall be strictly followed. No debris allowed to dumping around vicinity of highway, colony road, drain, nala, and rivers. The debris shall be transported and dumping into designated place, land, field, site. Third, land development is restricted to 500 square meters only. Shall maintain buffer zone of 5 meters.
You have to construct within 17/1/2026 to 17/2.
Yes.
But then the permit is valid up to 7/2.
No, this is a typographical error, I suppose, because the first line is now, Lordship, because I got,
Then what happened?
no, I got permission
You
from
started,
from 17th January it started.
you started,
Now you have,
17 January. What
Yes.
happened then?
now before that, Lordship, I just want to, Lordship, point out what should be done, man. Now, 5, man.
Hmm?
The condition 5, man. This is important, man. That's why I'm just sure.
Condition 5.
Yes. Shall construct U-shaped protection wall of 20 meters length in the west and 10 meters each in the south, north and south, wide with minimum height of 5 meters before the commencement of monsoon seasons.
Mhm.
Permissions of land development of 10,000, that's agreed. And 7th, man.
Hmm.
Permits are very subject to deposit refund security amount of 5 lakhs only, and same shall be forfeited partially fully in event breaches of terms and conditions specified above in order to restore loss and damages to public property by Itanagar Planning Authority.
So
No,
you have deposited.
yes, I have deposited 10,000 and 5,000 both. 10,000 and 5 lakhs both. No, I have started construction from 17, Lordship, in the next page 101. The construction, now Lordship will see the conditions of the area. Debris are there. And if unless I construct protection wall before monsoon, the persons who are residing above me, their properties will get damaged.
Okay.
That's 100% sure.
Okay.
Anticipating, I have that I have submitted representation when I'm skipping that. Now, Lordship will see the impugn order 105. A permission granted to Simiti Medu Dono Vibes Sonam, President Resinu Cherva, Colony Shepa, is coming district, Arunachal Pradesh for land development and transportation, debit dumping, nearby Hatha Resort, Itanagar against land allotment such and such at Gopur, Itanagar, with effect from here, Lordship will see the date. 7/1/2026 to 7/2/2026.
Oh, okay. That was not 17.
No, this category is wrong, man. That in the order it was.
Which one is wrong?
This is wrong.
Okay.
It is category stated.
Same person probably had.
Yes. Now that's why what I'm submitting here is that.
It should be 17/1 to 17/22.
Yes, 2026.
month.
Yes.
Okay.
Now, is withdrawn with immediate effect on grounds subjudice in the Honorable Court, Civil Judge, Judicial Division,
So how
UP.
many cases are pending?
Only one.
Complaint cases. Only title suit.
Title suit, only one case.
Five.
Yes. Respondent number 5, man.
Okay. So
Yes.
what is the stage of the suit?
Number documentation and issues.
Okay. No stay.
No stay.
No injunction.
No. Now, Lordship, that's why we have made the respondent 4 and 5 together, man. Now, Lordship, we can just see the here copy 2, man. In 6th number. Sri Tayatale and Sri Paching time for information, man.
So they are the.
Now, that means they have lodged a complaint before the Deputy Commissioner, man. This shows, yes, this shows that they have filed a complaint before the
What
respondent.
happened to the representation submitted by you?
Nothing, but the Deputy Commissioner has not even allowed the petitioner to enter to his chamber to discuss the matter.
Okay. Yes.
Now, therefore, Lordship, why I'm praying here is, Malad, this is the ex-face the illegal order, Malad. The license cannot be cancelled in such a manner without affording any opportunity to the
So
petitioner.
now you have been asked to
Yes.
stop
Yes.
the development.
Yes. Now I'm at risk. Something happens to the property of others, I will be the responsible. I will be responsible for that.
Now the authority has entered.
No,
They will be responsible. They have
but
stopped.
Lordship is aware of this matter. The property whose properties are above me, they won't go to court. It will be settled locally, and that's the problem now.
What the?
One thing can be done, Lordship. Let the authority consider his representation. That will be a bit earlier.
Now, because my is up to 17th February only. If after that, this matter will become infectious.
See, it appears unless there is an injunction, merely pending of the title suit before the court may not be, of course, ground for
That is good.
the cancellation, unless there is a stay, specific stay over
And so
or
not,
injunction.
then
Merely pendency of the case
Yeah.
cannot be the ground for cancellation, because during the pendency of this, probably the title suit, only this permission was granted.
Yeah.
So he has a allotment order, permission granted after consideration, it appears. Permission was granted only after
Everything.
consideration only, examination only. Permission cannot, permission for such development cannot be granted without examination, without verification, probably.
Yes, ma'am. The verification is done by the town planner, madam.
Heard Mr. Pitafo, land counsel for the petitioner. I've also heard Ms. N. Lawan, land senior government advocate for the state respondent number
1, 2, and 3, madam.
1, 2, and 3.
but it's also there.
Hmm?
Let the notice go, madam.
Okay, issue notice to the respondent. Returnable by 4 weeks. Okay. By filing this writ petition, the petitioner has sealed the. Where is the cancellation order?
Madam, second last, madam. 105, madam.
Yes, cancellation of the permission granted for land development. By the respondent number 2, Deputy Commissioner Itanagar. Deputy Commissioner cum Chairman, Itanagar Planning Authority, Capital Region. The challenge the order dated 19, say they write the date 19/1/2026, by which the permission for land development has been cancelled. So it is submitted that the just a minute. The petitioner claimed to have possessed the allotted land. Where?
Through gift deed, madam.
Through gift deed.
Yes.
At which place?
At madam, this may kindly be seen, madam. Gopur, madam. Gopur Tinali.
And wanted to develop the so therefore the petitioner sought for permission. Accordingly, the respondent number 2, Deputy Commissioner,
Page 99, madam.
granted
Yeah.
permission to the petitioner to for land development and transportation of debris, muck dumping at land development. Within And with effect from 17/1/2026 to 17/2/2026 with certain terms and conditions. Stop accordingly in compliance of the condition, the petitioner deposited rupees 10,000. 10,000?
Yes, and 5 lakhs.
10,000 is what?
5 lakhs. Permission, madam.
Okay, 10,000
Towards the planning authority, madam.
through treasury challan and another rupees 5 lakhs
To check, madam.
only by check
Yes,
before the authority
as security.
as security. Stop. However, however, the respondent number 2, the deputy commissioner, has subsequently by an order dated 19/1/2026 has withdrawn the said permission merely on the ground of subjudiced in the civil court, subjudiced before the civil judge, junior division UPR, staff, para. Then come the issue notice, returnable by 4 weeks. Since Mr. Enlong, National Government Advocate, accepted notice on behalf of the respondent number 1, 2, and 3, no formal notice may be issued. Stop. The petitioner shall take steps for service of notice upon the respondent number 4 and 5 by speed post with AD, as well as by usual process within a week from today. Stop. List this matter after 4 weeks. Stop. Para. Upon hearing the Land Council for the petition and on consideration, prima facie it appears that mere pendency of the title suit without passing any injunction preventing any injunction, the administrative order may not be it cannot be the ground for the withdrawal of the administrative order granted for limited period. That is also on the position of the on compliance of the conditions by depositing the depositing security amount. So in view of the above, and in view of the above, the petitioner has prima facie made out the case for granting interim protection. So accordingly, the operation of the interim order dated 19/1/2026 shall remain stayed till the next date of listing. Okay.
Much obliged.
List is after 4 weeks.
Much.
Item number 2.
Milind, the council is on its way. I'm seeking for a pass over, Your Lordship. He's just a few minutes away, 5 minutes away, Your Lordship.
Council correspondent.
Yes, the standing council for the university.
University.
He's just 5 minutes away, Your Lordship.
Okay.
No, this
We
is
can
only
pass
for
over the time.
but the issue of the notice.
Notice only. We can issue
Notice.
notice.
Oh, okay, Your Lordship.
Had Mr. Mukwatin. What is this matter?
The matter is that on 17/7/2025, an advertisement was made by the Arunachal Pradesh University, APU, at Pasighat. The the advertisement was made for appointment as assistant professor in various subjects. That is in English, commerce, economics, mathematics, sociology, Hindi, mass communication, social works, and travel studies. On the basis of that, in the advertisement itself, it is written that since APU, Arunachal Pradesh University, has got no own recruitment rules, entirety of the selection process would be governed by the UGC regulation. Now, as per in the advertisement itself, they say that the UGC guidelines shall be the ultimate basis of reference if there is any issue with regard to the recruitment of the above mentioned post. The criteria of shortlisting and evaluation will be guided as per established UGC and state government guidelines. But interview was held on from 3rd September to 26th September in various subjects, but they have violated the UGC's regulation, which way the selection should be done. They have not done. API, which is a mandatory to shortlist the candidate, but they have called all the applicants whoever applied for the interview. No API was applied as per the UGC norm.
There was no examination.
Yes, there is
No
Viva
written
was.
examination.
Viva was. And
Only Viva.
Viva.
And whosoever applied have been called for.
Yeah,
No
yeah.
Viva examination, no written examination.
No written examination.
So what is problem?
Problem is that
Because you have also been given an opportunity to appear,
yes, now
but you appeared.
yes, I appeared.
Okay.
I appeared. Now, when they say that they will follow the API in the advertisement, API, the shortlisted candidate.
They will
But
follow the
API, shortlisted candidate, as per the as in their own advertisement, they have mentioned it that they will follow the guidelines of the UGC. Now, application received in respect to the advertisement for the above mentioned posts will be scrutinized. Scrutinized is different. And shortlisted candidate only will be called for interview. Mere fulfillment of minimum eligibility criteria laid down in the advertisement does not entitle automatically a candidate to be called for interview. Now, that means whoever qualified, minimum qualification, that will not the criteria to call all the interview. But again, there should be a shortlisted. That is in their term and condition in their advertisement. Now, Annex 3 is the notification. It is the UGC regulation. UGC regulation. How they have violated the UGC regulation?
annexer?
Three.
Annex 3.
861.
Now,
Page 64, kindly come to page 64.
Yeah.
page 64, note,
Hmm.
uh,
Page 64.
the academic score as
Where are we?
down B or down B,
Hmm?
down B,
Capital B.
capital B.
PhD degree.
Yes, capital B. Notes the academic is note.
Note.
No, yes, down B, capital B.
Below capital B, there is a note in bold letters.
Okay.
Yes. The academic score as specified in Appendix 2, Table 3A for universities and Appendix 2, Table 3B for college shall be considered for shortlisted of the candidate for interview only, and the selection shall be based only on the performance in the interview. But yes, table 3A form is please do that. Page yes, 107, 109, page 109. Here, table A. How the candidates' academic records will be calculated and give the marks. Criteria for shortlisting of the candidate for interview for a post of assistant professor in university. Then graduation 80 such and such, 80 above 15 marks, 60 to less than 80 13 marks, 55 to less than 60 10 marks. So this is the criteria which they should follow. Then if this table is applied, strictly followed, then some of the candidates will not come in the candidate list. The object and purpose of avoiding the UGC rules is to select some of their own choice.
So, according to you, some of the candidates who were not eligible or qualified as per this have also been selected and you were not selected.
Yes.
Okay. What is your prayer?
And they have tried to do API also. That example I'll show you. That example is Annexure 15, page 236. They have tried.
Tried what?
Tried by giving some marks on the basis of that form table 3A. They have tried. This copy we got it from RTI. If this page 236, if this followed, if this rule is adopted,
followed.
Huh?
This was not followed.
This was not followed.
They tried means these are the candidates who have been selected
No.
from the same examination.
All applicants. And if it is followed strictly, then some of the selected candidate will not come. They are not qualified as per the API. Apart from that, when the selection board was constituted, as per UGC norms, minimum there must be 3 experts. 3 experts, but they have not constituted 3 experts, whereas they call 2 only, 2 experts. So they have not fulfilled the guideline and regulations of UGC. They have violated it. Again, the selection procedure, as they said, that as per state government guideline. State government guideline says, APC says, the ratio of selection is 1:3. So they have conducted the interview perfunctorily without following the UGC norm, nor they followed the state government policy.
When the selection was done?
Result?
Yes.
No, result is Huh? Berapa?
Page number 134.
134.
Page number 134.
This is the result.
Yes, this is the result.
September. Why you're coming now?
RTA documents.
No. We will apply RTI. And apart from that, as per Rules 8 of the APU Act, National Police University Act, we should approach to the governor, who is the chancellor of the university. So we have approached to the chancellor.
Okay. What did he do? Any order passed?
Chancellor has passed certain order.
184.
184. This is the to the Vice Chancellor of National Police University or National Police University, Hilltop. Now, advisory for recruitment process in the university. The National Police University Authority has made recruitment for various posts in the recent past for both teaching and non-teaching. It is to be mentioned that many complaints relating to faculty recruitment procedures, favoritism, misbehavior, or inappropriate question to the candidate have been received by this office. Therefore, for the transparent functioning of the university under Section 8(1)(14) of the APU Act, the Honorable Chancellor has directed the following advisory to be enforced without fail. For future recruitment of teaching posts, the university is advised to invariably.
This is for future, not for the examination which was conducted.
Considering our grievances.
Okay.
Considering our grievances, had we not been.
Okay. Anyway, so what is your prayer here?
My prayer is
To reconduct.
yes. Impugn notification dated on APU 34 dated 19/8/2025
This
by
relates to
National Police University, Pasighat.
result. This is result.
Shall not be set aside and quotes in respect of the department concerning the petitioner. Now, this is for selection of all the candidates. Is well in the preliminary scrutiny. Impugn notification result, memo number APU F number APU oblique 26, such and such, dated particular date 30/9/2025 shall not be set aside in court in respect of the department. Now, an order should not be, now,
Okay.
Fresh selection.
Huh?
Fresh selection.
yes, an order should not be passed calling for a fresh selection process for the post of assistant professor in department concerning the petitioners in adherence to the provisions laid down in UGC Regulation 2018 and state government guideline and with transparency to enhance public trust befitting a public institution. Now, here in the case, we have applied for, we have prayed for injunction order, interim order. In this interim order, we are the candidate. We tried to obtain score sheet. How I have been rejected, how the other person have been selected. I must, as a candidate, I must know the score sheet of my own performance. But the university has not, is reluctant to give us the scoring sheet. Now, here, my prayer is the court may please to direct the respondent authorities to place on record all relevant documents as a meeting minutes of the selection, executive committee meeting, copy of score sheet of all the candidates in interview. Score sheet. We have like, I am the candidate, I should know in which topic I got
We'll see
marked.
that later on. Mm.
Copy of API of all the candidates, timetable restart, etc., for better adjudication of the matter in the interest of justice, fairness, and equity.
Yes. You wish for the respondent?
I have not received the instruction, my lord. Therefore, notice may be issued.
Okay. You for the, there are private respondents also.
1 and 7.
Yes.
Okay. You have implemented all the selected candidates.
Not all the selected.
Okay.
Only few subjects.
Few subject.
Few subjects.
Mr. M. Partin, Land Synod Council, assisted by Mr. Makhom Partin, Land Council for the petitioner staff. I've also heard Mr.
Tigadi.
The Land Council appearing on behalf of the respondent.
Standing counsel for.
Standing counsel
Yes, ma'am.
for the
1 and 7.
respondent number 1 and 2, Arunachal Pradesh University, standing counsel for the Arunachal Pradesh University, within bracket respondent number 1 and 2. No, one only,
1 and 7.
1 and 7. Director higher also?
This is not record, madam.
You are representing 1?
1 and 7.
1 and 7, okay.
1, 6, 7, 6, 7, 6 also.
So then
1 and 6. 1 and 6.
1 and 6.
Yes.
So 6 is the chancellor?
No.
The vice chancellor.
Huh?
6 is the vice chancellor. 6, not 7. 6.
Why you have implemented chancellor also? There is chancellor also. And why you have implemented minister? Honorable minister is also there.
2, 3, 4, 5 is not required. Even 7 is also not required.
See, probably this honorable minister, chancellor is a governor.
Chancellor is governor.
Why? What grievances you have?
He is the head of the university. He is the chancellor.
No, executive council is the deciding factor of the university. Executive council.
But why minister also? What he will do with the recruitment? Is there his involvement? Are they necessary party?
We issue notice, not I.
You decide, and then we'll
it may
struck
be-
off
this is-
the party who are not necessary.
It may be struck out.
Which one?
Three may be struck out.
3 and?
And 7.
No, 3 and 6, 5.
2, 3, 4, 5 is not required, Mayor. And 7, even 7 also.
We issue notice.
8.
8 तो यहाँ तो मेरे को काम करना है.
Director hire is also not required.
Not required.
Not connected with the.
Yes.
Requirement.
Okay.
Respondent.
So we'll struck off. Okay.
2.
Okay.
3 and 7.
2, 3, 4, 5, 7.
The learning counsel for the petitioner prays for a strike of the name of the respondent number 2, 3, 4, 5, and 7. From the course title is they are not the necessary party for the purpose of adjudication of this case. The prayer is allowed. The respondent number 2, 3, 4, 5, and 7 shall be struck off from the course title. The registry shall do the needful. Okay. Issue notice. Calling upon the respondent to show cause Mr. Y.
And notice, we have given all the private parties under the care of Arunachal Pradesh University Hilltops. So we'll hand it over all the private parties petition to the.
No. How it can be?
To the
Issue
standing
will not
council.
be issued.
No.
Case
We
prayed
cannot
for.
receive.
And or why such further
Employees of.
or other orders shall not be passed as to this court may deem fit and proper. The notice is made returnable by 5 weeks. Okay. Stop, huh? The petitioner, since Mr. Okay, that we have already recorded. Since Mr. So-and-so, Gaddi, non-counsel appear on behalf of respondent number 1. No formal notice need be issued to the said respondent. However, the petitioner shall take steps for notice upon the service of notice upon the rest of the respondent. The respondent number 6, 8, 6 and 8 to 13. No, 8 to 16. Okay, by a speed post as well as by usual process. Okay.
And interim may also be
No, interim.
because the
What is
no, interim is that I am seeking for the
let them appear.
scoring sheet.
Let them file affidavit, and then if required, we'll call for the records. They may annex all the documents also, required documents, and if failed, and if required, we'll call for the record. Okay.
Then let them in the order, pass an order.
If they fail to
Yes, then we'll call for the record.
yes.
If necessary. Okay.
Order.
Yes.
List is matter.
Yes, it may be reflected in the order. It may be reflected in the order so that we will easy to make approach again.
The council, the petitioner also prays for calling out the entire record The petitioner also seeks direction to call for all the relevant record regarding the minutes of including the meeting minutes of the selection, executive committee meeting, copies of score sheets of all the candidates in the interview, copy of API of all the candidates, timetable, register, etc. The same shall be considered at the later stage. Okay. The prayer, the same shall be considered at the later stage. Okay. If required, at the later stage, if required.
Item number 5.
May I pay your lordship? My lord, this matter relates to levy of illegal tax upon the petitioner, which is exempted under section 10 of 2010 within bracket 26 of the Income Tax Act 1961. My lord, here the pleading has been almost completed. So matter may be posted for hearing. It's next hearing, my lord. It's required.
Okay. Mr. S.K. Deore, Line Counsel for the petitioner. Also, Ms.
Waiga, Lordship.
Line Counsel appearing on behalf of Mr. M. Kato, Line DSGI. It is
Lordship, for
submitted that the
respondent
pleadings
number
are
1,
completed.
Lordship.
Respondent number 1.
Yes, Lordship.
Okay. It is submitted that the pleadings are completed and the matter is ready for hearing. Stop. In view of the above, and as prayed for, list this matter for hearing after 4 weeks.
4 weeks, my lord.
Okay.
There is an interim order that may be continued.
There is interim.
Yes.
So the interim order passed RDS shall continue till the next date of listing. Okay.
Applies. Sir.
Item number 6.
Me, please, Your Lordship. Manoj, I'm appearing virtually in this matter. Manoj,
Yes.
I beg to submit that the arguing counsels had a bereavement in
Which
his
counsel?
family. Am I audible, Manoj?
Yes, just a minute.
Yes, Manoj.
But
May I go on?
just a minute. Yes, now you can see. Yes.
Yes, Manoj. Manoj, this writ petition pleadings are complete and it's ripe for hearing.
Okay.
Unfortunately, the arguing counsels had a bereavement in his family. If Manoj can put it after 3 or 4 weeks, Manoj, the matter is ripe to be argued.
Okay. You are for the petitioner.
Yes, Manoj, I'm from the petitioner.
Okay. Who is for the respondent? Yeah.
Lordship, I'm for the respondent number 1, appearing on behalf
They are
of
also
M.
same. Will fix for hearing then.
Yes.
If the pleadings are complete, similar or Well, your good name, please.
Mannat Vadej, Manoj.
Mannat.
Vadej. Manoj, it's ID
Counsel.
the first slip.
Your name has not been reflected in the cause list. Counsel for the petitioner. Heard Miss Mannat, Quresh, Lani Counsel for the petitioner. Also heard Miss Wangmo, Lani Counsel appearing on behalf of the state respondent number, Lani government advocate, appearing on behalf of not 1.
Lordship, I'm for 1.
Oh, you are for 1. Okay.
Yes,
Then
Lordship.
Gao for appearing on behalf of Mr. M. Kato, Lani DSGI for the respondent number 1, and Miss Wangu for Lani government advocate for state respondent number 2. Stava. They submitted that the pleadings are completed and the matter is ready for hearing. Staff. And as prayed for by the parties, come and let this matter be listed for hearing. After
3 weeks, Manoj.
4 weeks.
4 weeks, Manoj.
After
4 weeks is
Okay.
convenient. Well, it's interim
Okay.
order to continue till the next date. There's an interim order in
Sir, the interim order passed earlier shall continue till the next date of listing. Okay.
Much obliged.
Item number 7.
May I beg your lordship?
Yes.
Lordship, I am for the petitioner in this case.
Okay.
My lord, on the last occasion, This honorable court, the standing counsel for the respondent, Your Honor, my lord, they had sought time to seek further instructions. This matter is pending for almost a year now, and they
Okay.
haven't filed their affidavit also. And my lord, White order dated 30/10/2025. This honorable court was of the opinion and view that if they fail to file their affidavit or seek instruction, my interim prayer will be considered. It is almost a year, my lord.
It was listed only twice thereafter.
Yes.
No. May, okay.
The first order is of 22/5/2025. Which was only.
You are for the petitioner?
Yes, my lord.
El Parme for the
Yes, I'm on behalf of El Parme.
standing counsel. Whether he has got instruction, received instruction.
Lordship, we are yet to file our affidavit.
Have you received instruction?
Instruction?
In the last occasion, you prayed for some time to obtain instruction. What is this case about?
My lord, what has happened is that I was appointed as a contingency in a contingency service, my lord.
But there is an allegation that rampantly he was appointing.
Yes, my lord. My lord may come to page number 17, Annexure D. The impugn order, my lord. Now, my lord, by this order, 15 fresh appointments were made by the same appointing authority. And in the last line, my lord, it's written that any casual appointment issued by the undersigned other than the above shall stand cancelled, repeat cancelled, without assigning any further reasons, my lord.
There is an allegation that the executive engineer was making appointment randomly without any approval. This was made approval, and your was approved or not? Yours?
Yes, my lord. At page number 15, my lord. My appointment order.
Your name appeared here in this order, page 17.
No, my lord. These are the fresh appointments which he made later on, my lord.
Okay. Then you were appointed by the earlier executive engineer.
Same executive engineer.
Same executive
Yes, my
engineer.
lord.
So he revised,
Yes, my lord.
cancelled yours.
Yes, my lord.
So thereafter, what happened?
Thereafter, my lord, now I have been terminated from the service and this fresh 15 persons are in the service, my lord.
Whether these persons, their appointment was approved, received approval.
That, my lord, I have no idea.
Oh, you file affidavit.
Sure.
Okay, necessary, affidavit is necessary, and stay will not be possible because you have been out from the service since March.
March, my lord.
2025. It's not possible. Okay, Mr.
Yes, Your Honor, on behalf of El
Lanet Council appearing on behalf of Mr. El Parme Lanet, standing counsel for the Power Department, raised for further 3 weeks' time to file affidavit in opposition. The prayer is allowed. Mr. You are Mr.
Sanpat Sering, my lord, in the course list.
Sampa Sering, Lanet Council for the petitioner is present. Stop. Is prayed for by the Lanet Council for the respondent. List this matter after 3 weeks. But it appears you should file. We need to decide. You have to clarify this whether this 15 person who has been subsequently appointed, whether they have been appointed on the approval of the government or not. Okay.
Yes, Your Lordship.
Okay.
Obliged.
Lordship, list after.
Hmm?
List after.
List of the 3 weeks.
Item number 8 and 9.
Which I'm for the petitioner. Your Lordship, I'm for the petitioner, Lordship. Through this IA, we are praying for injunction against private respondents. Through this IA, we are praying for injunction against respondent number 3 to 10. Private respondent 3 to 10. Currently, they are felling trees in their disputed land. So that's why we are praying for it. Injunction, the Lordship.
Injunction against?
Private respondents. There is a disputed land between us and the private respondents. Both of us are claiming that land.
Whether the title suit is pending before any civil court?
No, Lordship. No.
You should make a prayer before the trial court.
Yes, Lordship. There was one complaint that was going on.
Why you are claiming this involved in the fact and dispute? How do this High Court decide?
Lordship, we filed this main writ petition because we were aggrieved by the fact that the ADC Machuca was going a bit slow. So in order to speed up the process, ADC Machuca, they had filed, private respondents had filed one complaint against us that we were cutting trees in the disputed land. Although that land belongs to us, despite that, they lost the complaint before the ADC Machuca, alleging that we were cutting trees in their land. So that's why they filed one complaint before ADC. So that complaint, that proceeding was going a bit slow. So we were aggrieved by it. That's why we approached this honorable court for speeding with the prayer for speeding up the process of proceeding before ADC Machuca, Lordship.
Speeding up the process?
Yes. Our only prayer is
for
disposable.
Whether the ADC has passed any order
not
affecting
yet.
you?
Not yet, Lordship. Not yet. It was in the middle of the proceeding.
Do you have any document to show that land belongs to you?
Yes, we do have. Yes, Lordship. It is in page number 19 of main
Whether that was filed before the ADC?
Yes, we did. We were granted the ownership in the year 2000.
Now, why before the ADC?
No, they have approached the ADC, Lordship.
Now, ADC, if the ADC has not passed any order,
Yes, Lord.
why you have come before this court?
Because we were aggrieved that the ADC was taking, it was the
How
proceeding.
the ADC will decide the title of the land?
Yes, Lordship, but
ADC cannot. Unless any order passed by ADC adversely affecting your interest, then what is on what basis you have filed? Challenging what?
we are not challenging.
You want this court to direct ADC to decide the title?
No, we are.
He has no capacity also, probably.
Yes, no capacity.
To entertain the criminal complaint if there is a felling of trees.
Yes.
It's a criminal action.
Yes, Lordship.
Then?
That is the complaint. And we were only seeking direction from this honorable court.
No, why? How? On what way will direct? If the ADC doesn't have any power or authority to decide a title,
Yes, Lord.
know the criminal case, how do we direct the ADC?
Your Lordship, we are just farmers, the petitioners. So
okay,
stopping us.
Now the farmers are represented by the learned advocate.
No, Lordship, we were just farmers, and for the past 2 years, we have been stopped from doing any agricultural activities in our own land. So this has affected us very badly.
Who stopped you?
There is one police officer. I mean,
Lodge complaint against that police officer.
I mean,
Why should he stop?
he has
Unless there is
instructed us to maintain
unless
status
there
quo.
is an order passed by any authority, state authority, preventing you from carrying on the cultivation.
Yes, Lord.
How do we interfere with? What thing is to be interfered with?
No, we are only.
There has to have some at least order adversely affecting you.
And we are
randomly we cannot just direct.
We are aggrieved by the Kebang decision of 2021.
Okay, then have you challenged the Kebang decision?
No, we are not. We have not raised an issue on that in this petition. We are only praying for direction from this court for early disposal of the complaint case that is going on currently. That is the only thing in the main writ petition.
I think it's not possible to direct to dispose of the complaint before the ADC, who doesn't have the authority to decide the title of the lane, because
Yes,
it's related to lane only,
Lordship.
pertains to lane dispute only.
Lordship.
And if we say that you decide, then he get an authority to decide, oh, I have a civil power. But civil power is with the judicial officer, civil judge,
Yes.
isn't it?
The authority lies before the civil judge.
Yes, that is why I'm saying. So if there is any action, whosoever prevent you, if you think that the land belongs to you, if any person cut down the tree illegally, you lodge complaint. Anyone stopping you, don't listen. And if they forcefully stop you, lodge complaint.
That is what has happened here. We were cutting trees in our land. As per the agreement, Kebang decision of 2000,
Now, who prevent you?
the private respondents.
Private respondent is
Yes.
a private respondent only. If he comes to stop you, that amounts to interference. You lodge complaint against private respondent. If you think that it's the action of the private respondent amounts to criminal act, you lodge FIR.
Lordship, the difficulty is that they have filed before us. We were not even aware. We were not even aware that, okay, they have lodged complaint. A notice.
See, you are not agreed by any order of the ADC. We cannot just confer any power to ADC to decide in that case.
Yes, Lord.
Unless he passes any order. Let him pass an order, come before this court.
Then
that way we cannot. How do we? Under what provisions? You just think.
And Lordship, at least direct the ADC to transfer the matter to civil judge.
Cannot. It is a complaint, not a title suit again.
Yes, Lordship.
Ah.
It is a complaint.
So ADC, if he think that it's a criminal act,
yes,
you are cutting tree illegally from the lane belongs to the complainant, then he will just direct to the police station only, forward it to the police station, register case. Let him do whatever, but we cannot confer any power to him to decide the matter.
Your Lordship, in that
Which is
case,
civil.
pleadings have already been exchanged. Everything has been done, but the matter is not yet progressing.
What way the pleadings have been exchanged?
Yeah, they have filed.
Lordship, the ownership has already been decided in favor of the private respondent, Lordship, by a Kabang decision, Lordship. And that Kabang decision has never been put to challenge by the petitioner.
You challenge that?
Yes, Lordship. Which means, Lordship,
That means land doesn't belong to you.
It belongs to us, actually, Lordship. That
You
land
already decided.
titleship
You are actually agreed by the Keba decision early.
Yes, Lordship.
Keba.
We are
Then
agreed
challenge
by
the Keba decision that then will pass order.
We will, but currently, Lordship, already there's a complaint case going on
No,
against
now the land belongs to him only. Unless you challenge the Keba decision.
And Lordship, one FIR has already been registered against them, Lordship.
Okay. Then you are culprit actually. It seems.
No, but we will be able to.
Now you are seeking direction.
Seeking direction against the ADC, yes, Your Lordship. If
Against ADC, we cannot confer. That
Yes,
will
Lord,
amount to
yes.
conferring power to ADC to decide a civil case.
True, Lordship.
That cannot. Under what provision? No, I think you have to challenge the Kaba decision.
Yes,
You
Lordship.
either withdraw this file with the liberty to file appropriate application, or just probably this may not lie also. What do you say?
Yes, Lordship, that's correctly Lordship. After especially past that notification of 2021.
Yes.
ADC doesn't have.
ADC doesn't have.
Does not have.
How can we say that anything in this between this is private and the petitioner, private respondent and the petitioner? We don't know whose name it is.
Better, liberty will be better
Yes,
to file appropriate application.
Yes, Lordship.
Because Keba decision, admittedly there is a Keba decision.
Yes.
You challenge
Yes,
that one.
Yes, Lordship.
And if there is any, before the appropriate forum, Mr. Eddie Pine, had Mr. Eddie Pine, land counsel for the applicant, also had Mr. G. Ete, land additional senior government advocate, on appearing on behalf of the opposite party number 1 and 2, and Mr. K. Lawyer, Land Council appearing on behalf of the opposite party number 3 to 10.
3 to 10.
Okay, stop at this stage. Mr. E. Pine, Land Council for the applicant. Praise for allowing him to withdraw this application. Along with the writ petition also?
Yes, Lord.
Along with the writ petition, with the liberty to file appropriate application stroke appeal before the appropriate forum. Okay?
Okay.
Because we do not know where you will file, maybe High Court or maybe before the civil judge.
Okay.
The prayer so made by the Land Council for the applicant petitioner has not been objected to by the Land Council for the respondents. So accordingly, the prayer for withdrawal is allowed. Withdrawal of the appendix IA as well as the writ petition is allowed with liberty as prayed for. Okay? Allowed, and the application stands disposed as withdrawn, huh? As withdrawal. Okay.
Deeply obliged.
Deeply obliged.
Item number 10 to 12.
May it please your lordship.
Yes.
My lord, here in this writ petition, my lord, the petitioners are aggrieved by the rejection of the technical bid, my lord, in the evaluation, my lord. Now, they are equally aggrieved by the acceptance of the bid of the private respondent on they are not eligible. Now, my lord, after the government has filed their respondent, the response in the form of an affidavit, my lord, they have accepted my contention with regard to the allegation leveled against the private respondent. However, my lord, my reasons have not been disclosed, but the be that as it may, the government has in their affidavit said that the tendering authority is yet to review the technical and the financial bid. So at this stage, my lord, what I'm praying is lordship can dispose this writ petition, directing the tendering authority to review the technical and the financial bid of the petitioner as well as the other bidders, my lord, and finalize the tender process.
Yes, my lord. We do not have
Okay.
objection, my lord. Yes.
Just a minute.
In fact, we have the SOP, my lord.
There is an SOP under that the tendering authority is the final authority who would review both the technical evaluation and the financial evaluation.
Page 513, my lord. In opposition of respondent number 1 to 5, my lord.
513.
513.
Affidavit.
Yes, affidavit in opposition of respondent 1 to 5. my lord. We will re-examine, my lord. Serial number 6 and 7. Page 513, my lord. Page 513, serial number 6 and 7, my lord.
6 and 7.
Yes, my lord. We have the power to review, my lord.
Yes.
The recommendation made by district board. my lord.
Tender document.
Our department, my lord, has two board system, my lord. One at district level and one at headquarter level, my lord.
Okay. So, just a minute. Huh?
Respondent number 3 is the tendering authority, my lord, who has issued the tender.
Respondent number 3.
3.
Okay. Now, that means by filing this affidavit in opposition, you
Yes.
have accepted.
Yes, my lord.
Yes, they have accepted.
Yes.
They have
Where
accepted.
do we find that paragraph?
Mostly our.
All
no
contentions
comment.
are admitted.
Yes, my lord.
Okay.
Yes, sir.
Okay, that means your prayer has been considered.
Considered.
Our stand is that, my lord, we will take grievance of the petitioner, my lord.
Hmm?
We will take grievance of the petitioner, my lord.
Hmm.
And the other bidders, my lord.
In fact, my lord, there has already been a review being done by the authority.
Okay.
But as there is an interim order operating, my lord, they could not take a decision, my lord.
Okay.
मेरा वाला रिप्लाई है इस केस का.
So this serial number 6 and 7, respondent number 3 has a.
Yes, my lord.
Okay.
Yes.
In para 12, my lord, we have stated that we will examine the bid of entire bidders, my lord. All the bidders, my lord.
Okay. Para 12.
Yes, my lord.
And page 523, if your lordship will kindly see.
What is that?
523.
What is that?
This is this is a letter, my lord, in the form of an instruction by the tendering authority, my lord, where they have already examined the documents of the tender documents of the respondents, my lord.
Where do we find that?
523, page 523.
523.
Yes, your lordship will find respond number 7. Yes, para number 7.
Yes, para 7.
Yes, and the reply, my lord, will find in the next column. All contents in this para are correct.
Okay.
So they have accepted that the discrepancies in the documents of the
Document otherwise reply.
these are the discrepancies in the documents, tender documents of the private respondents.
No, reply to read.
Parawise commitment.
Parawise
Okay,
comment.
this is parawise.
Parawise.
But then this was reduced into affidavit.
Yes, this is reduced into affidavit.
Para 3.
Yes. So, Malad, it clearly shows, Malad, they have already reviewed it. So now the further they need
para
to.
12.
Yes, para 12. The further what they need to do is to review my bid documents also. Because the affidavit is silent about why my bid was rejected, Malad. Because rejection was without any reason.
So your bid was rejected without any
reason.
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 So anyone given?
No.
No, not yet.
Not yet.
So that is why.
So that they can review it, Malad.
Okay, that is why.
As they have accepted that they will review.
Okay. So what was your prayer? Just a minute.
My prayer in the repetition is to.
No one was.
No one was allotted with the work, Malad.
Allotted, so that is why. And this.
I prayed for rejection of the tender evaluation committee's report, whereby my bid was rejected. Now, as they have agreed to review the entire thing, let the tendering authority take a call on this and finalize the tender process.
No need to go into the merit of it.
Yes, my lord.
Okay. So I'll pass order then.
My
Yes,
lord.
Mr.
B. Kaushik, my lord.
Kaushik, planning council for the petitioner. In all,
In all the petitions,
same, okay.
the packages would be different.
Oh, package only different,
Package different, NIT's dates are same.
dates are same, package different. So we need to mention the package.
Yes, my lord.
It has to be separate or at one go?
Separate orders should be.
Separate order. Yes, be convenient.
I've also heard Mr. Binta Picha. Line is standing council for RB department, huh? Yeah, huh? Okay, just a
ये
minute.
पर्ची पढ़ लो ये पर्ची पढ़ लो Item number 10 is, my lord, the name of the block would be Parsi Parlo.
This is Parsi Parlo.
Parsi Parlo.
Parsi Parlo CD block.
Parsi Parlo CD.
Okay, then this order will pass later on. Huh? Item 10, item 10, name of the
Name of the block
is Parsi Parlo.
Parsi Parlo.
And 11,
11 is Colorian
Colorian, and 12,
and 12 is Sarli.
12 is Sarli. Stop, huh? The bid are same.
NIT dates are
Same, the NITs are same for all the three petition. Item 10, 11, and 12 are the
NIT dated 20/06/2025.
okay, NIT, dated 20/06/2025.
20/06/2025.
Okay, 20/06/2025.
And the work is supply and procurement of material under MG and Rega, financial year 25/26.
Is there which
My lord will find at page 33.
page 33? Huh?
Page 33. Name of the work.
NIT is at page
Page 33, my lord.
yes. This is for
This is for Parsi Parlo. Name of the black down below.
Parsi Parlo. Name the work. It will understand. So name the block Parsi Parlo.
Parsi Parlo.
Okay.
And date, my lord will find in the next page, page 34.
Next page.
Next page, date, my lord, 20/06/2025.
Okay.
Name of the work would be same in all three.
Amount different.
Amount would be different.
You have annexed NIT in all the petitions.
In all the petitions.
Okay. Only the name of the block
Block would change.
would be different.
In WPC 472, it is Parsi Parlo. In 479, it is Colorian. And in 480, it is Sarli.
Okay. Okay. Dispose of. Huh?
My lord. My lord, the only limited prayer, my lord, this is a time-bound contract, my lord. It was about to be completed within 31st March of 2026. So the tendering authority, while awarding the contract, at their wisdom will consider the extension of time, my lord.
Extension, we have some problem.
Well, let the tendering authority take a call on this.
We will say the consider.
Yes. They will consider, my lord, at their own wisdom, my lord.
May consider
See, when till when you said?
Well, it It was required to be completed within 31st March 2026.
Just a minute, yeah. Within March
Within March.
26.
31st March. 31st March 2026.
Okay. Anything else?
No.
Okay.
Obliged, madam.
Obliged, madam.
Okay.
Item number 14.
Yes. No, yes, this is in chamber, huh? Disposal.
Grateful, madam.
Mm, mm. Mm. Yes,
Your Lordship, in this matter, the respondent number
this is item
14,
14. Yes.
respondent number 4 and respondent number 6 have been promoted. So we may be permit to implement the new incumbents.
Okay. Miss Sonam Som, Planning Council for the petition, submits that during the pendency of this contempt petition, the respondent number
4 and 7
4 and 7 has been
promoted.
And posted to some other department.
Yes. 4 is promoted in director.
Promoted, and in their place, some other
Yes, new
incumbent has been posted. Therefore, praise for allowing her to file
Yes.
implement of the new incumbent as respondent party. Okay.
Yes.
For which she required some time. She prays for how much time? 2 weeks.
3 weeks.
3 weeks time. The prayer is allowed. List this matter after 3 weeks. Okay.
Item number 15.
May please, Your Lordship.
Yes.
May please, Your Lordship. I am for respondent number 3, 4, and 5 in this case, my lord.
Okay.
And for the petitioner, my
So
lord, here
have you
I
filed
have.
affidavit?
Yeah, I have filed affidavit. Yes, additional affidavits had also been filed, my lord.
Okay.
Additional affidavit also has been filed where we have stated that we have complied the order. So I have been informed that they are also going to close the matter, my lord. In page number 73 of our additional affidavit, my lord.
Close the matter means?
My lord, they are going to, petitioner is going to close the contempt, my lord. I have been informed that, my lord. So one date may be fixed since I think he is not present today before the court, petitioner, my lord.
Yes, yes. Not present.
So, my lord, we have already complied the order also, my lord. In page number 70.
Not yet been issued. You are representing respondent number?
3, 4, and 5.
3, 4, and 5. Is there any other
Yes,
respondent also?
Yes, other state respondents are
There
also
are other
there, my lord.
respondents. 2,
Yes, my
6,
lord.
and 8. They have not yet filed. But then you have an information that the petitioner is going to close the contempt matter.
Yes, against us, my lord. I have been informed that. So, in the presence
What
of
is your
petitioner,
instruction?
I am appearing for respondent.
Respondent?
Yes, yes,
Okay.
respondent 9. I have already filed the affidavit.
On behalf of the petitioner on call. However, you are Miss
A. Gayan. A. Gayan.
Planning Council for the respondent number 3, 4,
3, 4, and 5, my lord.
3, 4, and
3,
5.
4, and 5.
5 and Mr.
Tishibo, appearing on behalf of Omodi for respondent number 9. We have already filed the affidavit.
For Mr. On behalf of Mr. O. Modi for respondent number
9
are present. In absence of the counsel for the petitioner, the matter is still adjourned. List this matter after 3 weeks.
My lord, kindly fix the matter because I have to physically attend
Okay,
to
when?
on 28th of February, 2020, my lord, February.
As requested.
It's
By the
holiday,
time.
Lordship, on 20.
20.
20 is holiday. 20 February is
20
holiday.
is holiday.
Sir,
20 February is holiday. Now it will be on
sorry,
18.
my lord.
No, not 18.
No,
So
not
that,
18, my lord.
okay, we'll say 23. 23.
23. Yes, my lord.
Okay. Let's pray for, let this matter be listed on 23. Okay.
Yes, Master
I
bless.
think. Hmm.
Item number 17.
My please, Lordship.
Yes.
My lord, in this matter, we are challenging the rejection of bail order that was filed by the petitioner under 167 CRPC. What happened, Lordship? The petitioner was arrested in case of NDPS. If Lordship will see, it starts from annexure to page 21.
Okay, so
in this,
arrested for offense under 21B.
Yes, the petitioner was not.
And charge sheet was also filed within, charge sheet already filed
Yes.
within time.
Yes. No. After
Not filed within statutory
yes,
period.
yes. So we filed a bail application under the mandatory
Okay.
that provision.
But it was rejected, thinking that the case was under section 21C.
Yes, ma'am. So therefore, here thereafter we filed a bail application before this honorable court. This honorable court said that unless you challenge the impugn order that has been filed by passed by the learned special court of NDPS, so we withdrew that bail application. We drew that bail application
19.
and we have filed this.
When you filed the bail application, when you filed this application before this court?
Yes.
Oh, no, this is not bail again.
No.
So you withdraw?
Yes.
What withdraw?
We drew the bail application.
From
this honorable court.
Why?
This honorable court was of the opinion that unless we challenge that order.
Okay. Then you challenge.
Yes, sir, then it would be better to challenge that bail.
I think so. It's already. We'll have to continue at 2.
Yes.
Otherwise, do you have objection?
No, my lord.
No objection.
No objection. My
Then
lord.
why should we waste time?
Yes, my lord. Yes, my lord. No, but your lordship, that the fact has to be clarified. That's it. Because my lord has to pass the order. So
Okay, at 2.
Yes. Okay, ma'am.
Law point is very clear, ma'am. We are only on the law point, ma'am, at this stage, because this honorable Supreme Court says once an application has been filed.
Application was filed.
Yes.
It was wrongly rejected according
Yes,
to you.
Yes.
So then he's entitled.
Yes, my lord. That is the exact position, my lord, here. Because the section cannot be altered in bail application.
Right.
That is there. That's clear.
And clarify.
Yes.
Yes, that's it.
Much appreciated.
10. Yes.
Manat, if lordship, so the impugn order, there's a page 31. Manat.
My lord, before that, my lord, kindly, I will find out the important date in TCR, my lord. The TCR is there, my lord. Okay, TCR on the country. I will find out my lord. The dates are not marked, my lord.
Okay. You want to find?
Yes, I will find out in the TCR, my lord.
Thora time lenge, 5 minutes.
Argo कीजिए.
So, my lord,
When he was arrested?
29/7/2025, my lord.
When the bail was rejected, the bail was filed?
Filed, my lord, the date of filing has not been mentioned.
Before the special.
The order was passed on 7/10/2025.
Okay. Hmm, 7?
10.
Charge sheet filed on?
Charge sheet has been, my lord, according to the forwarding, my lord, it was 4/11/2025.
No, it reached the court when?
Yes, my lord, that would be in the TCR, my lord.
Okay.
When the court received.
And then you filed bail application before this court?
Yes, well before it was forwarded, my lord.
Bail before this court?
My lord, before this honorable court, my lord, we filed bail application on 20. My lord, filed on 29/10/2025.
It was filed on 19/11/25. It was
29/10/2025.
Okay, 1911.
the charge sheet was received from the SDPO Nalagarh.
Okay.
This is the date when charge sheet was filed.
Mhm. And bail withdrawn
Yes, my lord.
when?
The, my lord,
Oh, madam, sorry, madam, that is not 19.
It-
That is 19, madam. The
Okay.
charge sheet filing date is 4/11/2025.
Okay.
it was withdrawn, my lord, on 18/11/2025.
Okay, this subsequent, this application is under?
Criminal petition, my lord.
Okay. Filed on?
Third day of December 2025.
And the criminal petition rejected or?
No, criminal petition was not, it was not rejected. Or that impugn order, my lord. Yes, that impugn order was of 7/10/2025.
Hmm? 17.
Yes.
Okay.
Now, my lord, two matters comes up here, my lord.
Hmm.
First of all, the law point which has to be decided is whether the learned a special judge could have altered the charges or not. But this is settled position, my lord. Charges can be altered only during the framing of charges, not before that, while hearing bail matter. So the learned.
So at the time of framing charge on?
No.
Charge framed on?
Not framed yet.
Not framed?
Yes, only cognizance has been taken.
Cognizance taken under?
Yes, 21C.
1911?
My lord, here again, my lord, it's there in the record. My lord will find, my lord, the charge sheet was filed under section 21B, 21A, as per the record, and 27. But however, my lord, the cognizance has been taken in another section. My lord will kindly see that because the cognizable order itself is, in my humble understanding, is perverse one, my lord.
Oh.
Because, my lord, the sections on the basis of which the charge sheet has been filed, on that section, cognizance has to be taken. Otherwise, if magistrate is not satisfied, then it ought to have sent back to the police for further investigation.
Has to be taken on the basis of the charge sheet.
Yes, my lord, we'll find, I marked the page, my lord.
Okay.
19, the date is
21C.
19. Yes, my 1911 something is there, date, my lord. That.
According to the cognizance, the offense under section 21C and 27A.
But, my lord, see the first part, my lord. The first part, my lord. The charge sheet is filed under section so and so and so.
Yes.
There, the section is different. Charge sheet is filed under different section.
But then it has to be under section, under the section under which the charge
sheet
has
was
been
filed.
submitted. And
Yes.
then only at the time of hearing on the charge.
Yes, my lord.
It can be altered.
Yes, absolutely.
Not before that.
Yes, my lord.
That's the law, man. Yes.
The cognizance order itself is, my lord, perverse one.
Now, my lord, now second law point that has to be decided, my lord. The accused person, their mandatory period was 60 days, my lord. And charge sheet was not filed. Therefore, the petitioner moved on bail application on default bail, my lord. and it was rejected by the learned special judge NDPS. Now, whether the rejection was right or wrong, whether the right to be released on bail exists even after filing of charge sheet, only that has to be seen, my lord. That we have, my lord. Not make it.
Okay. So you have no objection?
Yes, my lord, there is no way, nothing is there to my lord make objection because your lordship, the indefeasible was acquired there because the section.
When the police failed to.
Yes,
file
yes,
charges.
yes, my lord, yes. And the sections, my lord, which is there, it was earlier, it was 21B. It's a intermediate quantity and punishment is up to 10 years. So minimum punishment is not 10 years, life or death.
Okay, when charge sheet was filed, there is also 21A.
My
Went
lord,
down.
charge sheet, my lord, will find in the charge sheet, my lord. Sections, my lord, perhaps they have altered the section also against the present.
Yes. 21B.
Now, against Jiten Biswas, my lord,
So by, in this order 19/11/2025, sufficient material for commission of offense 21A.
Well, in fact,
What is this?
my lord will find in their charge sheet, they have annexed, my lord, page 44, my lord. My lord will kindly see the charge sheet is different section, my lord. 21A, it's a bailable offense.
Description niche mein. Last paragraph.
Okay.
44 last paragraph.
Wait, last. Under the above fact and circumstances,
Almost last second paragraph.
Page 44, my lord. 44.
Yeah.
Yes.
Yes, may I read my lord, last part? Under the above fact and circumstances, a prima facie case under section 21A, 27, 29 NDPS Act has been well established against accused Tanya Tatar. Accused number 2 is Jiten Biswas, the present bail applicant.
Okay.
And 3 is Puse Chetri. Therefore, I am sending. So, my lord, 21A.
No, so the present applicant is?
21B.
The present accused is? Biswas. No. Who is?
In section 21B, 27A, 29(2), NDPS Act has been well established in the accused
Okay.
Jiten Biswas.
For Jiten Biswas is 21B.
This is Jiten Biswas.
Yes, my lord. For Tanya Tatar and section under section 21A, 27, 29 is in respect of Tanya Tatar, and under section 21B, 27 small a, 29 subsection 2 of NDPS Act in respect of Jiten Biswas.
Okay.
So now under 21B, my lord, it was filed, which is non-bailable one. And the punishment prescribed is 10 years. So the investigation period would be 60 days, my lord. Yes, settled by the settled in Rakesh Kumar Paul case, my lord. 21B, my lord. So it would be 60 days, my lord.
Okay.
But in the impugn order, the learned special court, my lord, without going into the section, my lord, since they have straightforwardly approaching the court for default bail, my lord, has not exceeded his jurisdiction and altered this section 21B into 21C and held that the minimum the investigation period would be, my lord, if it is commercial quantity, then 180 days, which may be extended to 365 days if leave has been taken by the public prosecutor. There is the error committed by the learned court below, my lord.
Okay. So
if that order is, my lord, interfered, then his indefeasible right continue, my lord.
Okay.
Then he is entitled to be released and bail.
Heard Mr. Pitako, Learned Counsel for the petitioner. I've also heard Mr. AK, an additional PP for the state. Para. By filing this application under section 528 of the BNS Bharatiya Nagrik Suraksha Sanhita 2023, the petitioner seek quashing of the impugn order dated 7/10/2025, passed by the special judge POCSO at UPIA in connection with Banadwa PS case number 56/2025 under section 21B NDPS Act. The petitioner also prays for enlargement of the accused on default bail. Para. The fact leading to the filing of this criminal petition is that the accused Jiten Biswas was arrested in connection with the Banadwa PS case number 56/25 under section registered arrested on 29/7/2025 in connection with Banadwa PS case number 56/2025 registered under section 21B of the NDPS Act 1985. Write the full, the narcotic of the Narcotic Drug Psychotropic Substance Act 1985, within bracket here and after. Full as NDPS Act. Stop. Bracket close. Now, in that, the punishment under section, the punishment under section 21B is what is the punishment? The maximum punishment under 21B. Maximum punishment for the offense under section 21B of NDPS Act is
for the term it may extend to 10 years.
okay. Where is the NDPS? May extend to 10 years.
Yes, my lord. And with fine, which may extend to 1 lakh rupees.
Okay. With fine, which may extend to 1 lakh rupees.
Yes, ma'am.
On expiry of the statutory period of 60 days, the bail application was filed for release of the accused on default bail. Bail application was filed on 7/10/2025 for release of the accused on default bail, as the police has failed to file charge sheet within the stipulated time. Stop, However,
But observations page 32.
however, the said bail application was rejected by the learned special judge, NDPS, Ethiopia. Where, page
32, Madam.
30? 34?
32.
32? Where is the observation?
Madam, down below, though present cases, Madam.
Okay, with the observation that though the present case has been registered under section 21B of NDPS, however, an offense under section 21C of NDPS Act is attracted against the accused. Stop. Accused, and he is a habitual drug peddler having more than 5 cases, having involved in more than 5 similar cases. Stop. Being aggrieved. The petitioner filed bail application before this court on 29/10/25. However, this court observes that the petitioner required to challenge the rejection order passed by rejection order of the bail rejection order of the special judge. Accordingly, the petitioner withdrew the bail application on 18/11/2025 with liberty to file afresh. Liberty to file appropriate application afresh. Stop. Which was granted, Stop. Subsequently, on completion of the investigation, the police has filed charge sheet against charge sheet into the case submitted charge sheet into the case on 4/11/2025 against the accused on 4/11/2025 under section for offense under section 21B 21B stroke 27A stroke 29(2) NDPS Act. Stop. However, the learned special judge taken cognizance of the case against the accused. However, on 19/11/2025, the learned special judge NDPS has taken cognizance of the case under section
21C.
21C, 27A of NDPS Act.
Capital A, madam.
Capital A, No, The bail rejected in that paragraph, bail rejected. The bail was rejected. Okay. Just a minute. Have I? Okay. The observation we have recorded, no, all the. Okay. Just a minute. Where was the bail rejection order? Yes, although, yes, correct. That's fine. With Libert, subsequent file cognizance, okay. Thereafter, thereafter the petitioner has filed this criminal petition. Under section 528 of BNSS on on 8/12/2025. Stop. Para. The file code record as called for has been produced, and I have produced the same stock. From the record, it appears that initially the case was registered against accused under section for offense under section 21B NDPS Act, and on expiry of the statutory period, when the police failed to file charge sheet against into the case, a bail application was moved for release of the accused on default bail the Land Council for the petitioner submits that on expiry of the statutory period of 60 days in the present case, the accused has accrued an indefeasible right to be considered for his bail. Consider for his release on default bail. The Land Council for the petitioner further submits that although the bail application was moved for his release on default bail, the Landed Special Judge NDPS Ethiopia has rejected the claim of the petitioner on for default bail, release on default bail, by treating the case as on one under section 21C of the NDPS Act 1985 and not under section 21B of the NDPS Act. Stop. He further submits that the Landed Special Judge wrongly held that the section 21 wrongly held, sorry, that in the beginning of this sentence, wrongly held that it is under section 21C, huh? And that the section 21C of the NDPS being commercial quantity, the statutory period applied would be 180 days. So, the Islamic Council for the petitioner further submits that in the instant case, the initial registration of the case is under 21B of NDPS Act. And he filed for release of the accused after expiry of the statutory period and when the police failed to file charge sheet, and therefore he is entitled to be released on default bail. And subsequent filing of charge sheet and alteration of the offense would not disentitle the accused for default bail who had already accrued earlier before filing of charge sheet and alteration of the charges. Stop. Para Mr. Ete, line additional PP, fairly submitted that since the initial registration of the since the case was initially registered under section 21B NDPS Act, the petitioner filed for release of the accused on expiry of the statutory period of 60 days when he was 60 days when the police failed to file charge sheet. The petitioner would entitled to be released when the petitioner accrued an indefeasible right to be considered for his release on default bail. And the subsequent, when the charge sheet was subsequently filed and by an order dated 19/11/2025, the offense, the cognizance of the offense was also taken under 21C/21 capital A of NDPS Act. What was the last sentence? Okay. Okay. Which would not, which is a subsequent. Okay. The subsequent filing, I have written subsequent, no? Okay. Which would not help, which would not disentitle the accused who had already accrued the right under indefeasible right prior to the filing, indefeasible right prior to the filing, prior to the subsequent development. Stop. You have any ruling? Okay. You have also?
My lord, I have furnished earlier, my lord. Perhaps it's a part of the record, my lord.
Okay.
My lord, the judgment name, the citation is perhaps it's in the record, my lord.
M. Ravindra.
Yes.
Intelligence officer.
It is not on record, it appears.
We have
It is in the, is it in the other copy?
2021 2 SCC
Yes.
485.
Where is the other copy?
Last para, I think.
Hmm. That's good.
Okay.
2021 2 SCC.
Okay, then in the submission of the petitioner, in support of his, no. Where is the copy of, other copy, the other file? The Learned Counsel for a petition, in his, in support of his submission, the Learned Counsel for a petitioner relied on the judgment.
485.
Direct.
Rendered in, what is the name of the party? Page?
M. Ravindran versus
M.
Senior Officer Director of Revenue Intelligence.
M.
Ravindran.
Page?
485. 485. 485.
Okay, M. Ravindran versus Intelligence Officer, Directorate of Revenue Intelligence.
Yes.
Reported in 2021 to SCC 485. This is para?
Last 25 1, my lord.
25.1, madam. Last para, madam. 25.
518.
Page number 518.
518.
518.
25 1.
Yes.
8.1. Once the accused file.
Okay, which rate is, huh?
Once an accused files an application for bail under provision.
Page 518, huh? Okay. Type it, huh? Once the accused file an application for bail under the provision. Yeah. Okay, and yours is?
Madam, same, madam.
We are relying on the same judgment.
Same judgment. And my lord, the other judgment regarding my lord, the alteration of the section, my lord.
That may not be required.
Not required, but my lord, it's also reported, my lord.
Okay.
Just my lord, it's not required, but it's a 2014 3 SCC 659. The stage for altering the section is the considered while framing of charge.
In his submission, if further submits that. No. Oh, no, in continuation, which per se is. This is wrong order, or what do you say?
My lord, since they are not impugning this
not impugning, of course.
cognizance order, but my lord, the order which they are challenging,
Hmm.
the order, the rejection of the bail order, there, my lord, this can be relied upon. Why? Because my lord, there while considering the bail application, the learned special court do not have any power to alter the section.
Okay, in his submission, then the Learned Counsel for the petition further submits that the offense registered against the accused cannot be altered at the stage of bail or at the time of taking cognizance.
My lord, the cognizance, my lord, cognizance part may not be included because they have not impugned the cognizance. Yes, only on bail. I will limit my submission. Yes. So there, my lord,
considering the bail.
Yes, ma'am.
In this regard, he relied on the judgment of the Honorable Supreme Court rendered in State of Gujarat versus Girish Radhakrishnan Verde, reported in 2014 3 SCC 659.
Yes, madam. To para 14, madam.
Para 14, huh? Wherein, which is the para 14 is reproduced here in below. Huh? Okay. Para. Once the accused file application for bail under the provision of section. So new the BNSS section, you have filed under 167. What is the
No, my lord.
corresponding
Yes.
section? You have
It's,
filed
528. my lord.
Hmm?
528.
528.
No,
no, not
or
528.
default bill, my lord.
187.
187 2.
187
2.
2
Yes.
within bracket, corresponding section 167 2, comma, the bracket close. He is deemed to have availed or enforced his right to be released on default bail, accruing after expiry of the stipulated time limit for investigation. No, leave that, Once after expiry of the statutory period of 60 days in the present case, and once the bail application is made for his release under this section, that section, the accused has accrued an indefeasible right to be released on default bail. Stop. The court, in this regard, the court has no discretion. The court cannot exercise any discretion. Stop. In view of the above, and in view of the submission made and the law laid down in the above referred judgment, and also in view of the provision provided under section 187
bracket 2 of BNSS.
Okay. I'm of the view that the petitioner has made out the case for his release on default bail. So accordingly, this petition is allowed. I'll correct the last part. The petition is allowed. The order dated
Yes, 7/10/2015.
7/10/2025 passed by the Honorable Special Judge UPIA is set aside. The accused, since the accused is entitled, the accused already accrued an indefeasible right to be considered for his release on default bail. The prayer for release of the accused is also allowed. Stop. Accordingly, the accused is directed to be released on bail, on default bail, on execution of a bail bond of rupees 1 lakh with one surety of.
It's very
It's
poor person.
It is provided in the
that is the ultimate.
1 lakh.
That's when punishment.
What is the amount? It's a 50. 1 lakh.
Yes, my lord.
We can fix 50.
Yes, my lord. It's
Okay.
your lordship discretion, my lord.
With one surety like amount. Subject to the following terms and condition. One, that the accused shall not. The accused shall appear on each and every date. Appear before the trial court on each and every date fixed, unless exempted, okay? Two, that he shall not hamper or influence the witnesses in any manner. That he shall not commit the similar nature of offense under NDPS or any other criminal offense during the bail period. Okay, that on in the event of his it's fine only.
Yes.
Okay.
Yes. My lord, this matter, my lord, kind of pro bono only I'm doing, my lord. It's very poor person. My lord. It would be kind of, my lord.
Observation, have you seen? He is involved in more than 5 cases.
My lord,
It's only because he is entitled on default bail. Otherwise, you see, such person is very dangerous, difficult. It's only because on low point he is entitled.
I don't know, but whether he would be able to afford the amount.
He will be able to. He will be.
Much obliged.
Obliged, my lord.
Item number 18.
May I please, Your Lordship?
Yes.
There's been a delay in taking steps upon private respondents, Your Lordship. But therefore, my prayer is I may be allowed to take fresh steps.
First step.
Yes, Your Lordship.
In view of the office note dated 28/1/2026, Mr.
M. Taso, Mindo Taso.
Direct counsel for the petitioner. Praise for allowing him to take fresh steps upon the respondent number 5/2/26.
Yes, Your Lordship.
Stop prayer allowed. Steps upon steps for notice upon the respondent of 5/2/26 by a speed post with 80 agents by usual process.
Yes.
Within a week from today.
Yes, Your
Okay. List this matter after
2 weeks.
3 weeks.
2 weeks.
2 weeks, you will not be able to.
Okay. 3 weeks, Your Lord.
3 weeks. Mr. Ira Lane, government advocate, is present on behalf of the state respondent. Okay.
Obliged. Obliged.
Item number 19.
Here, Your Lordship, we have received the extra copies today itself, Your Lordship. I
Mr.
may be
Ira
granted
Lane,
some more
counsel
time.
for the Lane government advocate for the state respondent submits that he has received the extra copy of the petition today itself. Therefore, he needs some time. He requires some time to go through the same and to obtain necessary instruction in this regard. The prayer for the prayer is allowed. Mr.
Stiga, Lordship.
Mr.
Stiga, Lordship.
Lane counsel for the petitioner. And you are for?
Lordship, I'm for respondent number 7.
7 is filing affidavit?
Yes, Lordship.
Okay. And Mr. Yes, Ira, Lane counsel for the respondent number 7 are also present. Okay.
We have already filed our affidavit.
Okay.
Yes.
Okay. Then petitioner present, Mr. S. Ira, Lane counsel appearing on behalf of the respondent number 7, Mr. He has already filed affidavit on behalf of the respondent number 7. Okay. Let's pray for Kama. List this matter after 3 weeks.
Yes, Your Lordship. 3 weeks.
Okay, 3 weeks. Okay.
Obliged.
Deeply obliged.
Item number 23. Item number 23.
None appears. Well, that will none appears for the parties on call. They stand adjourned. List this matter after 4 weeks. Okay.
Item number 24.
May I please, Your Lordship?
Yes.
So,
in the midway of the trial proceeding of this writ case, my grievances has been fulfilled by the respondent authority.
Hmm.
So this is the order. So I am now posted at Changlang CD block. I was transferred from Pangsu block belonging to directorate without any post. Therefore, I filed this instant writ petition, but the respondent authority already given me the proper remedy.
Okay.
So I have no grievances now.
Mr.
Matter may be closed, my lord.
Mr. Yudeka, Learned Counsel for the petitioner submits that during the pendency of this writ petition, his case, his grievance has been considered, and by an order dated 22/7/2025, he has been transferred and posted at
Changlang CD block.
Changlang CD block.
Serial number 4.
Serial number 4, my lord.
Okay, CD block Changlang
Yes.
is what?
As video, my lord.
Is video, huh?
Yes.
Okay. Is video headquarter, and therefore he has no further grievance against the respondent authority. Therefore, he prays for closing the matter. He is no longer pressing the matter. Stop, huh? Hence, pray for closing the prays for closing the matter. Stop.
Yes, sir.
Mr. Yadav, Learned Counsel for the respondent.
Number
Yes.
4. Respondent
Number 4 has no objection. Stop. Huh? In view of the above, this writ petition is closed on not being pressed.
Yes, my lord. Highly obliged.
Yes, stands disposed of. Huh? Okay.
Matter is over. Matter is over.
Complete.
The